Okay. Hello, everyone, and welcome. Thank you for attending the Future of Abortion in America, a virtual town hall discussion for students. My name is Katie Crashel. I am a clinical lecturer in law at Yale Law School, where I co-teach our reproductive justice clinic. I am also, importantly today, a former student fellow at the Petrie-Flom Center, and I'm always happy to be back. The Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School is delighted to bring you this event. Before we start our discussion, a few housekeeping items. Our hope is that you all will help us drive today's discussion, and we will follow a town hall Q&A type format. The best way to submit your questions is via the Zoom Q&A feature, which if you scroll down towards the bottom of your Zoom window, you'll see a little button marked Q&A. Just type the question in there. I'll be checking it very frequently. You're also welcome to join the conversation or submit questions on Twitter using the hashtag Abortion Town Hall. Again, that's hashtag Abortion Town Hall. If you do submit a question there, the Petrie-Flom staff will be monitoring it, and I will pull it into the Zoom Q&A feature. Ways that you should not try to submit questions. The raise hand feature on Zoom, we will not be checking that feature. And we've also turned off the chat function so that our panelists can really focus on what's going on in the discussion at hand. So that's not a venue for you to submit your questions. If you are interested in this event and interested in other health policy, bioethics, biotechnology topics, we strongly encourage you to sign up for the Petrie-Flom Center newsletter, to read their blog, The Bill of Health, which features some really cutting edge commentary by legal scholars. All right, with that, I will launch into today's event. I'm honored to be joined by an all-star panel of experts to discuss the future of abortion in America. First, we have the Professor Glenn Cohen, the faculty director of the Petrie-Flom Center, and the James A. Atwood and Leslie Williams Professor of Law, also Deputy Dean at Harvard Law School. We have Louise Perkins King, Assistant Professor of Obstetrics, Gynecology, and Reproductive Biology at Harvard Medical School, and a surgeon in the Division of Minimally Invasive Gynecologic Surgery at Brigham and Women's. And last but certainly not least, we have Mary Ziegler, Stearns Weaver Miller Professor at Florida State University College of Law. Thank you three for being here. And again, I would encourage everyone to submit your questions. We really hope that this can be a lively discussion that can focus on the topics that you are most interested in hearing about. With that said, I will go ahead and start with a few questions for our panelists. And, you know, Mary, I know I mentioned you last, but I'll come to you first. Can you just start us off by telling us, you know, people are talking about SB8, these cases making their way back and forth, ping-ponging to the Supreme Court. Tell us what is SB8? What's going on?
So SB8 is actually connected to something else people may have heard of, so-called sanctuary cities for the unborn, which was a movement begun in Texas by a fellow named Mark Lee Dixon, who is an evangelical minister. And the idea was that towns wanted to ban abortion, which is obviously impermissible given that there's a constitutional right to abortion. So Mr. Dixon and some of his colleagues in Texas designed what they saw as a kind of way around that. They would outsource enforcement of these bans to private citizens and then claim that states had sovereign immunity from suit. So some of you in the litigation of SB8 may have heard of a case called Ex parte Young, which was decided in the early 20th century. Ex parte Young essentially says that there's a way around sovereign immunity. People can go to federal court and seek an injunction against a state official enforcing a potentially unconstitutional law. So Mr. Dixon and his colleagues were hoping that if cities swore off the possibility of enforcing the law and claimed that only private citizens would do so, that would be a way around Ex parte Young. These sanctuary cities bills seem to be working quite well. And the same thing seemed to be true. There was another kind of forerunner of SB8 called the Save Chick-Fil-a bill that arose when Texas, the San Antonio airport tried to exclude Chick-Fil-a as a vendor because its owners had donated to anti-LGBTIQ organizations. Again, the strategy was to create rights for religious believers who felt that they had been discriminated against, but to outsource enforcement privately. So SB8 was sort of, if you will, like a sanctuary state, right? That was the idea, that you would sort of build on the sanctuary city model but implemented at the state level, and thereby insulate state officials from lawsuits, and particularly from having to pay attorney's fees to prevailing parties, which Texas had done in 2016 after it lost another Supreme Court case, Holman's Health versus Hellerstedt. It had been out over $2 million. So lawmakers wanted to pass what amounted to an almost complete ban on abortion without having to potentially pay the other side attorney's fees. They wanted a ready-made group of enforcers because Texas is a state that's vast geographically, and it's very hard to know if someone is having an abortion, much less taking an abortion pill, without a network of informants. And they wanted a way around the fact that progressive prosecutors had already signaled that they may not be willing to enforce heartbeat bans, especially as early as 6 weeks of pregnancy. So SB8 was designed to sort of solve all of these problems at once, to sort of give conservative lawmakers in Texas and beyond a way for them to have their cake and eat it too. And when the Supreme Court let it go into effect in early September, it already sparked interest in other conservative or red-leaning states in similar bills. So there's one that's been filed in Florida, for example, and Florida is certainly not the only state considering adopting a similar strategy.
Great. Thank you, Mary. Glenn, we'll turn to you next. So that's sort of what SB8 is and where it's come from. Where is the case now? Can you tell us, where is it procedurally? What's going on?
Yeah, so I'm going to resist my urge to be a true civil procedure professor, and I'll give you the short version, which is just to say the law, unsurprisingly, was challenged almost immediately in Texas. We had a district court judge who was prepared to hear a preliminary injunction and potentially give a preliminary injunction. But then there was an objection, essentially, that there was no proper defendant to sue. Who should be sued to restrain the actions on this? There were a bunch of theories involved, but essentially the Fifth Circuit, and a supervisory authority over the district courts in Texas, intervened in such a way, or not intervened in a technical sense, but acted in such a way to prevent the fulmination of that consideration of a preliminary injunction. We went up to the Supreme Court to say, allow it to go forward, the stay or the preliminary injunction. The Supreme Court did nothing. The United States stepped in essentially to try to bring its own suit on the theory that the United States could sue Texas as a whole using its kind of power as a sovereign. There was litigation on that. That was also appealed to the Fifth Circuit and to the Supreme Court, and the Supreme Court heard argument on November 1st on both cases. And I think I'm sure we'll talk about reading the tea leaves about the oral argument and where it's likely to go. But if you listen to that argument, if you tuned in on November 1st, hoping to get an exciting discussion about the direction of abortion and the importance of abortion, what we were treated to instead was a highly technical conversation about ex parte Young and what it extends to and what it doesn't in various theories. Now, I think Justice Kagan might have captured it best when she asked a question, say, so some genius came up with this kind of scheme, right? But the question is whether actually it's, crazy like a fox or just crazy, and the Supreme Court will be the one to determine that. I think many people, and I'll be curious what my co-panelists think, though, is that, well, SB8 is incredibly important, and I think Dr. King will talk about the on-the-ground effects. In some ways, it's the sideshow, and the main show will be the Dobbs case that will be argued in December regarding a less, but not that much less restrictive abortion law that I think many people believe will be the one that will change the substantive law of abortion in a much more significant way. And if I could just say, one more thing is that if we extend our kind of gaze all the way back from Planned Parenthood v. Casey, right, there was a certain momentum, I think, in Whole Women's Health v. Hellerstedt, which was a case decided, not a huge momentum, but this is related to targeted restrictions of abortion providers' trap laws. And then just a short time thereafter, with a change in the composition of the court in June Medical, the Supreme Court didn't didn't change its mind as to an exactly identical law. Our majority of the justices did not, but certainly wrote an opinion in such a way to signal to people that the abortion law is likely to change and it's not nearly as protective of abortion rights as it was in Whole Women's Health. And I think we'll see the fulmination of that with Dobbs coming up, and I know we can talk more about that. But most people think we will get a Supreme Court ruling probably in the next few weeks, perhaps just before the Dobbs case, perhaps just after the Dobbs case is argued, and we can talk about what that's likely to be, but that's the current state of play.
Excellent. Thank you, Glenn. And finally, so we've talked about what SB8 is, where it's at in the courts. Louise, what can you tell us about, from a provider perspective, what's going on in the ground? Glenn made a great point about, what the argument was really about. It didn't seem to focus a lot on the people who are seeking abortion care in Texas. So what's going on? Can you tell us that?
I can. I should clarify, of course, that I don't provide abortions in Texas, and I don't primarily provide them in Massachusetts, although I do provide abortion care. But my colleagues who are dedicated to provision of these services and necessary services feel a deep sense of frustration and anger at the way that this is going forward, and fear, honestly. There are unsubstantiated reports, but probably pretty reliable ones, that there's been at least one death related to this, sort of related to the confusion. It's difficult to get to decide if you're in the realm of providing an abortion that would come under this law versus an abortion, because it's the same word for us as medical providers, in the setting of a miscarriage. So there's a report of a young woman passing away, bleeding to death, because nobody was sure what they could or couldn't do under the law and didn't want to take on that liability. Again, unsubstantiated, but very possible, and I believe an accurate report of something that's happened. Providers are frightened and again, deeply frustrated by their inability to provide what we consider to be essential care within obstetrics and gynecology, recognizing that there is a proportion of our populace who believes that it's immoral, and I know we will talk about that at some point. It's still currently everyone within the American College of Ob Gyn would consider it essential care.
Great, thank you. I just want to make one more plug again for if you have questions, to drop them into the chat or to post them on Twitter at #AbortionTownhall. With that, let's shift gears a little bit. So that's sort of the moment in time that we find ourselves now. Mary, can you you've done a lot of great work on the history of Roe and a history of abortion in America. You have a book out about it. How did we get here?
Well, I think that one of the major things that brought us here was a shift in the anti-abortion or pro-life movement away from the idea of a constitutional ban on abortion, which is still ultimately where we're going. And there are briefs in the Dobbs case reflecting that, which we can talk about later. But after Roe, there was a sense that the route should be a constitutional amendment that would ban abortion everywhere, right? It would make abortion unconstitutional in Massachusetts as well as Alabama. Anyone who knows anything about constitutional amendments knows that that doesn't often work, right? There's no equal rights amendment. There's not going to be an anti-abortion amendment. Just doesn't seem, it's a non-starter. So instead, the movement began to come up with a plan B. And that plan B looked increasingly like making abortion a core political issue in our national elections, influencing what became a political partner in the GOP to pick justices who would vote to overrule Roe, who had a jurisprudential philosophy that suggested that Roe was wrongly decided, to introduce laws in states that would tee up challenges that would give those justices the opportunity to either whittle away at abortion rights and make them incoherent or eliminate them altogether. That strategy was a strategy of necessity at the outset, and in some ways it still is. One of the more striking things I think about the history is that that's often lost in discussions. There's a built-in assumption that if Roe is overruled, this will return to the states and that will be the end of the matter. And that's an argument that makes a pretty significant appearance in briefs in all of the cases before the court right now on abortion. But it's a mistaken assumption, because the movement that has brought us to this moment in some ways is not a states' rights movement. It's a right to life movement. And much as those who believe that there's a right to choose abortion believe that that right applies everywhere, those who believe that there is a right to life believe that that right applies everywhere. And that there's the meaning of the word person under the 14th Amendment encompasses fetuses or unborn children. So where we are now is really, I think, a point in a strategic trajectory that began with Roe v. Wade. And we're beginning to see, I think, a little bit of a fraying of that strategy as people in states like Texas are breaking with the script that's been written by DC-based larger anti-abortion or right-to-life organizations, and pushing the envelope. And more often, I think, writing laws that reflect what they would really like the law to be. So there are lots of manifestations of this. There's the elimination or falling away of rape and incest exceptions, which had once been a sort of given in political consensus on abortion. Those are a rarity now in the new laws coming out of these states, including but not limited to SB8. We see it in the fact that states are reaching for bans earlier and earlier in pregnancy. The 6-week bans of the kind that SB8 represents are actually seen as compromises now within the right to life or anti-abortion movement because they don't go all the way to fertilization. So I think where we are now really is kind of a fork in the road where we're going to return to a debate where we're not talking anymore, for example, about the reality of abortion. For years, we were talking, debate was, for example, many of you will be familiar with arguments that abortion hurts women. It's obviously that would include other pregnant people too, but the argument is basically that abortion hurts women as women, and that there is no tension between eliminating the right to choose abortion and equality for women because abortion itself ultimately damages women's psyches and bodies. That argument is falling away, and we're returning to kind of, the brass tacks original purpose of the movement, which of course centered on fetal rights. We're at a fork in the road too, I think, because we're beginning to get a preview of what a post-Roe America would look like, instead of seeing laws in the states that are more designed to tee up a perfect case for the Supreme Court and to maximize the odds that Republican politicians will be elected. We're moving away from that model to more a model where we see what lawmakers and movement members would actually like the country to look like.
Thanks. And I believe, I'm sorry, I may have misspoken, used to a different format for my Zoom moderation. If you have questions, please drop in the Q&A box, not the chat. That was explicitly what I told you not to do at the beginning of our conversation. So my apologies. Please put your questions in the Q&A box. And not to ruin that beautiful transition, but I think that, Mary was talking about shifts in how we think about the right to abortion and the competing interests, and, one of which is the state's interest in fetal life. And Glenn, you're a bioethicist as well as an attorney. Wondering if you might put on more of the bioethicist hat and sort of tell us about the contours or what your thoughts on, the ethics behind ideas about viability, things like fetal pain.
Yeah, so people are often surprised because they know from litigation positions I've taken that I'm firmly in the pro-choice camp, but I'm also somebody who finds abortion to be a very tough issue, right? So that's news for some of you, that you can think both things are true. Women should have a right to abortion, and abortion is morally and ethically a very difficult area. So if we look at the larger picture since 1992, it's really been a pincer movement. And so I often say, when you look at the 3 most successful litigating organizations of the latter half of the 20th century, it's gay marriage, guns, and abortion restrictions, because the amount of different and interesting attempts to restrict the abortion laws has been really kind of unprecedented, right? So on the one hand, we have trap laws, which we've talked a little bit about, targeted restrictions on abortion providers, which seem to grab facially neutral kinds of rules about admitting privileges or the space you have in your hallways. We have attempts to really go to the root of things with personhood bills, and we can talk about that, claiming fetal personhood. We have the heartbeat bills at 6 weeks. We have fetal pain bills saying when a fetus begins to feel pain is the point at which abortion ought to be restricted. We have attempts to control information, so either by requiring certain speech to be made to individuals seeking an abortion, or requiring them to be confronted with an ultrasound, or prohibiting certain kinds of speech. So it's really a wide variety of seeing what sticks. Now, the Dobbs case, which is the one that will be heard in December, will put the most pressure on the decision in Planned Parenthood v. Casey to treat viability when a fetus is viable as an important deciding line in the constitutional treatment of abortion and the state's right to regulate abortion and the state's interest in the preservation of fetal life. From a bioethics perspective, I will tell you, you'll find very few bioethicists who would defend viability as a morally sensible line as to when an abortion right is a moral matter, ought to attach or not to attach. One of the reasons this was foreshadowed near the beginning by Justice O'Connor in some of her opinions in these cases is it is by definition a moving line, and right now it is a line that sits somewhere at around 21 weeks. It could actually move even further back, and there's no reason to think that the moral status of an embryo ought to depend on the external fact of the world of what the technology for sustenance is. It's also always been a little bit strange that at the period of time when a fetus can be sustained, and we should talk a little bit more about what it means to sustain a fetus, whether we're talking about quality of life judgments or just a chance of sustaining. It's always been a little bit strange that at the point when that can happen is the point where a woman can no longer have an abortion should a state seek to restrict it, right? There's something that just doesn't quite compute on the logic. It is, I think, at best defended as either a political compromise between people who would rather have more or less as a moral matter, or perhaps as a rough proxy for something else that we're seeking to get at in terms of the developing capacity of a fetus. But it's very hard to kind of go from that rough proxy to the things that seem to have moral weight, either on the side of women's autonomy rights and their ability to control their bodies, or on the sides of personhood as an accretive phenomenon that is progressing as we get closer and closer to a born child. So I'll just say that bioethicists, by and large, have been largely dissatisfied from the standard as a moral matter. And whether or not they'll ride for Casey, I think depends on whether they think the alternatives the court is likely to endorse are worse from their preferred bioethical perspectives or better, rather than because they think viability is such an excellent dividing line.
Thanks. So Louise, Glenn does this great job of talking about the role of viability in fetal pain and how that integrates with the law. As somebody who understands the medicine and the science behind concepts like fetal pain, the debate about fetal pain, what you think about the clinical significance of the idea of viability and how that intersects with the abortion right. Tell us what you think.
Thanks. First of all, I agree completely with you, Glenn, that abortion is such a difficult topic. Even I am obviously pro-choice and provide abortion care. And most abortion providers still find it very difficult to navigate from a moral standpoint. But realistically, 80 to 90% of women who would seek out, or persons who would seek out abortion care, will do so in the first 12 weeks of pregnancy. So the question of viability is almost moot, except in exceptionally difficult circumstances. And in those exceptionally difficult circumstances, we're looking at a fetus that is potentially viable in the sense that it could be born with a heartbeat, but might be born without a brain, or might be born without the ability to survive or meaningfully survive without significant difficulties, for lack of a better term. And then frequently in those situations, when we're talking about abortion care at 22 weeks or 23 weeks, we're talking about a woman who's facing a cardiovascular compromise or something where we're just trying to save a life. And in those scenarios, legislating around the incredible complexities of the medical decision-making and informed consent that we have to achieve to reach the best course of action for a person who is pregnant but very ill, for example, and their family, it's just not helpful. It doesn't really help anyone, and there's such infrequent circumstances. For people who provide this care, we're consistently frustrated by the incredible amount of legislation around that. By contrast, these bills that focus at 6 weeks, when the vast majority of persons couldn't possibly know that they're pregnant, just based on the regular menstrual cycle and when we can actually test for pregnancy, is kind of absurd. I mean, there is really very little ability to achieve an abortion in that time frame, if that's what you're seeking to do. In terms of fetal pain and these efforts to achieve personhood or achieve a status of personhood for fetuses, of course, it doesn't really make a lot of sense The fetus doesn't experience pain to any great degree, or to a degree that is meaningful, until maybe 24 weeks. And even then, there's still a question of whether there's a true perception of pain as opposed to actually feeling pain. So the neural development is just not possible from a physiologic standpoint. So I hope I've answered your question, and conveyed that it just becomes very frustrating, because really what we should be focusing on is even those persons who in our communities and our populace who wish to see significant limits on abortion, is the vast majority of abortions occur through medication so much earlier. And if that's what they're trying to limit, fine. But this focus on viability is a question that really only arises for us clinically in very complex cases.
All right, so thank you everyone who's put some questions into the Q&A. Keep it up. I will turn to you all and synthesize a couple of questions together that are on the same thread. So there's a lot of speculation about what the court will do, both in the SB8 cases and in Dobbs regarding the 15-week ban. What would happen in a post-Roe world? Let's say that the court does make a ruling that drastically changes the right to abortion. So two questions come out of this. Like, what do you think that would look like? What shape could that take if the court moves in that direction? And what do you think the future is for activism to help people maintain access to this type of healthcare? And I guess I could tee that up to Glenn first.
Sure. Maybe I'll just start. So one thing to say is that I actually am somewhat optimistic about the SB8 case. Now, I'm optimistic in a very cynical way, because I think it's advantageous to say, well, not quite what Texas has done, and then make Dobbs look by, default a little bit more kind of reasonable. And it's kind of a, so I think that, so one other thing I'll just say slightly by the side, Katie, to your question, is just that I think going into the Dobbs argument, many people I think thought the United States was going to have the stronger argument for its case to go forward. After the Dobbs argument, I think it's actually the private plaintiffs that are going to have their case go forward. And if anything, the Supreme Court would like to avoid deciding whether the United States, but I don't think they're going to be able to avoid it completely, but that was the strong sense I had. So I think probably SB8 will be remanded back to the district court to consider it. And depending on the timing, it may also ultimately not get remanded back in light of whatever they say in Dobbs. So the district court may grant a preliminary injunction, make a decision, but the case may itself not be resolved until after Dobbs, and then there'll be another take a look at SB8 in light of Dobbs. So if we get rid of viability, here's I think the very difficult question for the court, which is, what do you replace it with, if not a return to states may basically restrict any abortions they want? There have been some proposals from some kind of originalists, but left-leaning originalists, to look at quickening as kind of the analogy, and that would create a new rule. I have no idea whether that's going to be appealing to the justices or not. But let's imagine that whatever rule we get out of here turns out to allow some states like Texas to restrict many, many more abortions than they could under Whole Women's Health or even June Medical. What we're going to end up with is a country that begins a checkerboard statute that essentially is checkerboard state of play, where we'll have places like Massachusetts that will basically permit abortions till quite late, and states like Texas and Louisiana that will prohibit just about any abortion they're constitutionally allowed to do so. And the pressures then will be a couple. First, as Professor Ziegler said, one of the big things will be, it's wrong to think that this is truly a states' rights movement and that people will be satisfied. Instead, there will be movements now to essentially whatever Texas and Louisiana adopt, to have that be constitutionally required rather than constitutionally permissible. I'm not sure whether the politics will line up to permit that anytime soon, but that will be the next vanguard. The other thing will be, on the left, there will be attempts to, and this is very in keeping with reproductive justice thinking, enable women in restrictive states to be able to either get medical abortions or to travel out of state for medical abortions or non-medical abortions. And there will be countermeasures by some of these states to try to prohibit it. And here, believe it or not, all sorts of interesting questions about choice of law dormant commerce clause, and a whole bunch of other doctrines of constitutional law, I think will now be activated in a way that we haven't particularly seen, except for the period before Roe, where we did have states actually seeking to criminalize abortions in Mexico or something like that. And there'll be all sorts of questions about how much of the conduct has to occur in a state in order to do this. And maybe the last thing I'll just say is we might have a little bit of a preview from Ireland in the period before the repeal of the 10th Amendment, by the Travel Amendment in Ireland, where we had cases about leafleting and stuff like that, whether you could provide information to women about options for abortion outside of Ireland. And we had a series of cases on this. We may see some of that as well.
Great. Professor Ziegler, would you like to take a stab at this one?
I mean, I think if we're thinking about this from a movement standpoint, I think on the abortion rights side, we're likely to see what we really haven't seen in the past 50 years, which is a much more, I think, a much greater focus on access. It's always been easier to focus on rights than access. It's been easier, and if you're a historian, you see why in multiple ways. It's easier because it pulls better. It's easier because it appeals more to the people with deep pockets who are donors. It's easier because it resonates with people who tend to be, you know, the most educated, the most wealthy, and often therefore white. And it tends to do better with politicians whom you need after abortion has become a political issue to move legislation at the state or federal level, or more often, if we're talking about abortion, to block state legislation that you don't like that's coming out of conservative legislatures. So I think if Roe is gone, there's going to be a focus on access in ways we really haven't seen. I mean, we've seen some kind of not necessarily successful attempts to shift from rights to access, for example, on the Hyde Amendment, which deals with Medicaid reimbursement for abortion. That shift's never really taken hold in some ways. And so I would imagine that a shift to access will be focusing on both legal strategies for access of the kind that Professor Cohen laid out, and also illegal strategies for access. There's going to be a debate, I think, within the movement about how much people are going to be willing to send abortion medication where it's illegal to do so, or facilitate other people accessing that medication when it's illegal to do so, or to perform abortions for folks from out of state when the kinds of legal uncertainties that Professor Cohen described are present. So I think those debates about access and to focus on access are what we should expect on the abortion rights side. On the anti-abortion side, I think there's going to be a debate not only about how quickly to push for personhood, which has always been the objective. So there'll be a strategic question about whether it's realistic to expect the Supreme Court to give you that. Of course, there's no realistic possibility that that's going to be achieved through the democratic process anytime soon. There'll be a question as to whether a Republican Party would want that kind of outcome in states, or want that kind of outcome imposed by a Supreme Court. But I think that debate will unfold, and a parallel debate will unfold in each state about what it means to ban abortion in the first place, because we're all assuming that we know what abortion is. That isn't true historically either. The definition of abortion, in particular, the boundary between abortion and contraception, or abortion and certain forms of fertility care, has always been contested. For the most part, we've seen this bubble up. For those of you who've read the Hobby Lobby opinion, for example, there was a question about whether emergency contraceptives or IUDs were abortifacients or contraceptives. In movement circles, this debate has been much more intense over a much longer period. And the stakes, of course, have been relatively low because states have not been able to criminalize all or most abortions. If that changes, you would expect to see that kind of debate too. What exactly are states intending to criminalize? What exactly, as a matter of constitutional permissibility, are they allowed to criminalize? I expect to see that change too. And probably relatedly, just as the Overton window moves, if Roe is gone, there will be tremendous constitutional fallout from that too. You already see in briefs some sense that if Roe is gone, maybe that should cast doubt on other substantive due process opinions as well. That traditionally would have been an argument made by progressive attorneys to convince the court to stay its hand and to preserve Roe, so as to not endanger those other foundational substantive due process precedents. Now it seems you'll see more conservative lawyers arguing, in fact, that the court should revisit cases like in Obergefell versus Hodges involving same-sex marriage, or Lawrence versus Texas involving sodomy legislation. And I think we may see more in that vein as well. So I think there may be, in sort of constitutional lawyerly circles, a debate about the fate of substantive due process decisions beyond those in the abortion context.
And Louise, what do you think? I mean, what do you see the future looking like in a post-war world clinically? And I know you've mentioned medication abortion a number of times, and we've seen a lot of, there's a case about medication abortion and FDA regulations that has been in play during COVID. What role do you see for medication abortion, and what do you see the post-Roe world, for clinicians across the country?
I think Mary hit on it as well, and in discussing that there's fear and uncertainty about whether can I prescribe to somebody in Texas, for example. And it's important to recognize that although medication abortion is typically the best way to proceed in early moments of a pregnancy, it's very painful. And it's not that you wouldn't necessarily need to be seen in person. I mean, it's not uncommon for women to have to present to an urgent clinic because of bleeding related to a medication abortion. So you need supports in place. It's not that we can just do this completely virtually. I think access is going to be an incredible, it's going to be very difficult for us to ensure access for all women around the country. And that inequality is extremely disturbing to most OBGYNs. There's a question in the chat related to something I'd stated earlier about whether all obstetrician gynecologists in the United States support abortion rights. And just like the general populace in most surveys, 80% of our general populace supports access to abortion of some kind or another. I think a similar proportion of obstetrician gynecologists, but an even higher proportion would support it. The American College of Ob Gyn is an organization that not all OBGYNs belong to, but at least 90+% do belong to it, and has very strong, long-held statements in support of abortion rights. And I think the reason for that, certainly we allow for trainees to opt out of abortion training. That's a requirement, and we do allow them to opt out of that training. So there are obstetrician gynecologists that do not provide abortions. Many, in fact, only 14% of OBGYNs actually do provide abortion care. But they still support access to it, the vast majority, even those who would never have trained in it or would never have provided it. And I think the reason for that is in our training, at some point or another, we've watched a woman die related to a pregnancy that she didn't want to carry forward, or an abortion that that was performed much later and could be much more traumatic, or something along those lines. We've seen the consequences, even in our modern era, of limiting women's abilities to access this essential care. And if you are forced to carry forward a pregnancy all the way to term, that is exceptionally more dangerous than it would be if you were able to terminate. So it's not just a question of this sort of, well, you should do the right thing. You're taking on a high risk of mortality, one of the highest in the world, in fact, for our American populace. And that's a lot for a person to take on. It is a very big deal to go forward with a pregnancy, and you will be risking a lot. We do our best to make it safe, but it's a big deal. So to then say that you don't have that choice, even very early on when medication abortion would be effective, is incomprehensible to most obstetrician gynecologists who have actually seen the consequences firsthand.
Professor Krashel, if you don't mind, if I could just underline two things that Dr. King said, just to amplify them. One is just this, she said it subtly and gently, but I'll say it more forcefully. For people who believe in reproductive justice, right, the fact that maternal mortality in the United States is where it is for a country as developed and as established as us compared to our peer countries is really kind of a real problem. And it's a real problem that people across the political aisle should be really focused on. The second is just to say that when it comes to medical abortion, you've now introduced another factor, which is FDA and the federal government, the control of it. And one of the things we saw during the pandemic is FDA had a REMS for mifepristone, right, which basically was extremely difficult to then access mifepristone during the pandemic, and went to the Supreme Court and said, people said, this is problematic, and the Supreme Court ultimately, over dissent, basically said, no, actually, FDA has a lot of authority. So partially how strongly you should feel about medical abortion as a source of success may depend a little bit on how strongly you feel as though that FDA will continue on the current path it is today on medical abortion versus a future where one could imagine an FDA that's more restrictive.
Yes, and if I may, as my reproductive justice students know, I'm a little bit soapboxy about the brief the ACLU filed in the FDA REMS case to tie together the reproductive justice thread. In my humble opinion, I think that brief for students who are thinking about what a reproductive justice lens in advocacy in this space looks like, I think it's an excellent example, as is Justice Sotomayor's dissent in that instance. All right, well, so I want to press you guys a little bit further, if I may, if you'll indulge me in a thought experiment that weaves together some of the Q&A. We've talked to sort of looking down at a checkerboard, right? Looking down from up above at all of the states. But if you were in a state legislature, if you were in a purple state, a blue state, and a red state, and you were to say, this is the type of policy that I should be advocating for in my state. This is the thing I should be doing. I've had a lot of students from across the university reach out to our clinic and say, what can I do? So sort of on the ground, grassroots level, what do you all think? How should people be directing their energy at this point?
I think so. Here's something that I think. Let me throw something out. And again, as a non-woman on the panel, let me just. When I think about the things that have been some of the most impactful things, they've been actually the most personal narratives. When I look at the briefs filed in the Supreme Court by women who tell the stories, prominent lawyers, clerks for the former justices who tell the story about what it is like to be a woman whose body is governed by one of these regimes, to me, that has, as a legal matter, been one of the places where I think the advocacy has been most successful. So I love initiatives like that. I also do think that the state houses are incredibly important, but typically, and this is, I think, a little bit of our biases as law professors, is that we focus and we direct our students and we think a lot about the federal and and the like. And I think the movements that have really tried to take back the state houses, the importance of them could not be understated when it comes to abortion, because I think the future will largely be determined by state legislatures and by governors' offices. So get out the vote efforts, efforts against certain kinds of gerrymanders. These are the kinds of things that I would probably spend my time on.
Yeah, I mean, I would add in state constitutional litigation, even, I mean, I think even grassroots protests, because I think if you look at, so I live in the South at the moment, right? So if you look at laws emerging in the South, they don't always track polling in those states. So that might raise the question, okay, well, what's going on, right? Why would a state like Florida that has probably roughly say like 55-45 pro-choice, why would it be considering adopting a law like SB8? And I think the answer really has to do with intensity of political preference. So there's a working assumption that politicians have that people who are opposed to abortion care much more about that and are much more likely to vote or give money based on those preferences than people who are in the proverbial mushy middle or people who are in support of abortion rights. And so when they legislate on abortion, they're catering to the people with the most intense preferences, not to the greatest number of people. And so I think anyway, so I mean, obviously, if you are opposed to abortion, you want to reinforce that feeling by donating, by protesting, by suggesting, I think, the opposite of what appears to be true, which is that people who are opposed to abortion are becoming dependent on the Supreme Court and complacent. If you are supportive of abortion rights, I think you want to be disrupting the narrative that you don't care that much, and that when the rubber meets the road, you're going to vote because of other issues, whether that's your concern about the pandemic or global warming, that abortion is not ultimately a priority issue for you. It's not something, or reproductive justice generally is not something that's going to get you out on the streets or get you to open your pocketbook, right? That's an assumption that a lot of politicians have. And I think it's especially urgent to send that message in state elections, because while I don't think that this is the last we've seen of even federal judicial involvement on abortion, I don't think the overruling of Roe v. Wade will be the end of that. We have 50 years of history to suggest that when we believe the Supreme Court has resolved once and for all federal constitutional litigation about abortion, that presumption tends to be grievously wrong. I think we'll see that, but obviously that process will take some time. And in the shorter term, we'll be likely to see litigation in state Supreme Courts, which will be incredibly important. And we'll see laws coming out of state legislatures. So I think paying more attention to that, even when it doesn't seem to be, and I mean, I would, in addition to what Professor Cohen said, it's not just law professors, it's the media, it's most of our sort of thought leaders who focus on federal rather than state elections. And if reproductive justice or abortion is something that you care about, you'd be well served to direct your attention elsewhere.
I would say, having lived in the South and done a lot of outreach, that one of the most important things you can do is try to figure out where your common ground lies with people who oppose abortion rights. And typically it's that they'd like to see fewer abortions. And if that's the case, especially in the South where education is lacking, I found it really helpful to go out and create community outreach efforts to educate young women and older women about the history of abortion, the history of contraceptive rights, the history of women's equality rights, how they're all intertwined, what they can and can't access in their state, what they can and can't access outside of their state, and how to make change within their own communities. And so when I worked in Dallas, Texas, or in Louisiana, we would go out and just talk to people. And it's a lot of time and effort, but that's where we're going to achieve change, because a lot of people are unfortunately completely unaware of how deeply this actually affects them. And so educating them to that is really important. Additionally, I had found, and there's a great book written about this called Scarlet A, I believe, but there are a number of people who are deeply, profoundly, strongly working towards less abortion rights, yet access abortion themselves. And talking to those people and explaining that if they, and I've cared for those people, and when I explained to them, you can't have a system where you're the only able to access this because of your resources and someone else is not. And really trying to get through to people about the needed equality and access is what I focus on.
Great. We have one question that was submitted before the panel. Thank you to that question submitter. So we've talked about the future of abortion care, but what does it mean based upon the mechanism that was used in SB8? I want to pose to the panel, especially Glenn, maybe. What do you think will be the next or future applications of SB8 enforcement mechanism? Not just private enforcement, but lack of state enforcement to avoid 1983 suits before laws take effect.
Yeah, I think if you listen to the oral argument, this is what's on everybody's mind. And I think it was actually very helpful for the challenges at SB8 that one of the gun rights organizations filed a brief kind of turning from what was a theoretical point, or they could do this for the Second Amendment, into like very much in front of you. You know, I think that if the Supreme Court does what I do not expect it to do, which is to allow the SB8 process to unfold the way is envisioned by Texas, I then think it is possible that you will see copying and pasting of it into other statutes across the political spectrum. I imagine, even though it's possible that it will be significantly left-leaning directions, that it will be asymmetric, that instead, in part because I think there is something about it, even if to copy an abortion statute as a left-leaning person and a left-leaning legislature, I think is going to be somewhat politically unpopular, whereas to copy on it for someone who's a fellow traveler as to abortion, I think is likely to be much more politically popular. But the Supreme Court, I think, correctly views this. So what's interesting about this case, I'll just say this, that there's two very different currents here that are both interesting for the Supreme Court. There's a states' rights current, but then there's also a judicial supremacy current, because the Supreme Court justices, as much as they might support states' rights, they also don't like people basically doing complete end run around what they say the Constitution says it is. And that's why I think ultimately the second instinct will take over. I think it's going to be complicated, though, how they get to the theory that allows this case to go forward. My sense is that Justice Sotomayor might have had the approach that will do the least damage, which is to analogize this to the Attorney General and the Attorney General's power over prosecutors that's what this is like. Going into the argument, I would have thought the argument about clerks being proper defendants was what was going to win the day, but I sense significant concerns by the court. And we might view this case along with New York Times versus Sullivan and Shelley v. Kramer as these three places where something mysterious occurred. Hard to explain exactly what the stopping principle was, but everyone kind of agrees that the result was the right result in this case. And I think that's the challenge, is to write an opinion like this. Maybe they'll surprise us and decide that actually the genius in this case has won and beat the Supreme Court, but I don't think that's what's going to happen. We've frozen, Professor Crashel, and I think maybe Professor Crashel, go ahead.
I'm back. I'm sorry I didn't hear the end of your remarks, Professor Cohen. I wanted to shift gears a little bit, unless Professor Ziegler has it, or Dr. King may have anything to say on that point. All right, well, we'll shift gears a little bit to another question that was dropped in the chat, and I think Professor Ziegler, this might be best for you to talk about. To address the impact of legislation currently in the works, HR 3755, the Women's Health Protection Act. What impact do you think that might have on anti-abortion legislation proposed in so many states that you mentioned?
Well, the Women's Health Protection Act would be quite effective. I mean, its approach is sort of twofold. There's a sort of iteration of common abortion restrictions, which the law prohibits, most of which are restrictions that have been in the news recently. And then there's a sort of catch-all that generally forbids states from singling out abortion and treating it differently than comparably safe medical procedures. And so there's obviously the hitch with the Women's Health Protection Act is whether it can pass, which seems unlikely given both the present composition of the Senate and the prospects for the 2022 election, and then whether the Supreme Court as currently constituted would hold that it's constitutional, because of course there would be questions raised about Congress's authority to pass it. And I think there were within the movement questions about whether the Women's Health Protection Act went far enough in the direction of reproductive justice. One of the things that was often raised in debates about it was its exclusion of abortion funding. Now, I think it was the separation of the funding and access issues was intended to make the bill easier to pass. Skeptics, I think, wondered if certainly thought it would be unlikely that there would be multiple federal bills on abortion or reproductive justice or rights anytime in the foreseeable future. So there was a sort of, if there's only going to be one shot, it should be more capacious and more inclusive than this bill is. There were others, I think, who were concerned that while the bill does have a catch-all, it seems to be fairly keyed to present day regulations of abortion, which sort of underestimates the creativity of the anti-abortion or right to life movement, which has been, endlessly inventive in coming up with new restrictions over the past 50 years. But I think at the moment, the reason we probably haven't talked more about the Women's Health Protection Act today has been because the obstacles to its passage at the moment seem insurmountable, which is why change at the state level seems more realistic and probably important in the short term.
Great. We have another question in the chat that takes us into an international frame. So how do you think the results of the cases before the court in the US will reflect on other countries' sexual and reproductive rights? And the questioner provided the example of Colombia right now going through a moment in their constitutional court discussing whether or not to remove providing abortion from their penal code.
Maybe I'll start. So first of all, I want to give a shout out to the work of Alicia Yamin and also Chloe Reichel and our group from Bill of Health. That there's been some great symposia on the most recent Mexican decision, for example, and the like. The trajectory here is in the opposite direction of where the United States is going. Mexico, even Ireland, right, have gone in a way that is less restrictive of abortion rights. I tend to think that these are two solitudes, that while there be a few places where more restrictions in America might perhaps tilt an argument one way or the other. I just tend to think the world has the view that our constitutional structure and our constitution is fairly unique in this regard, and I don't know that you'd see a lot of exportation over. I could be wrong, and maybe I'm underestimating the impact of the United States, but on these issues, our structure is already so different from even our peer countries like England or Canada or Israel in terms of the way they regulate abortion, that it's a little hard to think whatever the Supreme Court does in Dobbs will be easily ported over. But I'm very curious what my colleagues think.
I mean, I think the only thing, I mean, so one thing I know from, I'm actually editing an international collection now. Roe in particular, not Casey, Roe has had this sort of weird magnetic pull on some courts in other countries that use it as a touchstone debate, even while they don't particularly find its logic compelling, and even while they resist the idea that US law should have some sort of special place of privilege in constitutional debates in other jurisdictions. So there may be some kind of persuasive effect if Roe is eliminated. I think the more likely thing would be a kind of further internationalization of the anti-abortion or right to life movement, which has already been internationalized. There are groups like Human Life International, which is working everywhere from Ireland to Mexico to Brazil to parts of Asia. If there's been a successful attempt to unravel a right to abortion that itself was kind of won through decades of effort, that playbook will be exported. And so we've already seen the internationalization of that movement. I would expect we would see much more of that. There's already a lot of money and a lot of tactics that are used abroad that were first forged in the United States. I would expect we would see much more of that. Whether that pays off or not, I think we won't know for some time after Roe were to be overruled, but I think you would expect to see lots of social movements and lots of jurisdictions trying their luck.
All right, well, I am very mindful of our time and that we have 3 minutes till the end of our time together. So I guess at this point, I would just ask if the panelists are each open to it. I'm an avid Rachel Maddow fan, and so I think of watch this space often. So if you were to sort of pick one thing for our audience to be focusing on moving forward in the next few weeks, what part of the space would you be focused on in watching the space?
Maybe I'll start. So one is that Mary Ziegler is going to be visiting us in the spring at Harvard Law School, so watch the space because you'll have more opportunities to interact with Professor Ziegler. The other will be, I think, the Dobbs oral argument. I think will be the thing that I will probably be listening to, and I think it'll be much more accessible for non-lawyers than the SB8 oral arguments.
And that's December 1st, right?
Yeah, I mean, I would agree on Dobbs. I mean, I think SB8 has been, it's easier for people to relate to because it's already in effect, right? I mean, we're already seeing what's happening in Texas, as Dr. King described. But in terms of where we're headed in the future, Dobbs will likely set that course. And so I think someone described once SB8 as sort of the toddler that runs into the room and screams and cries and draws attention away from whatever else was going on. And in this case, I think that was Dobbs. I think the Supreme Court has had a plan on what to do about abortion. I think they chose Dobbs as opposed to other cases for a reason. And so I'm watching, you know, for signs as to what that plan might be on December 1st.
I can only say that as clinicians, we're going to be watching and hoping that there may be some light at the end of the tunnel, although I'm not terribly hopeful for one. Tons and tons of discussion about how to ensure access for women and keep this essential care moving forward. But honestly, very few ideas of how to do so. So we'll be watching for your leads on how we can do that without incurring liability that would mean losing licenses and not being able to provide care moving forward.
Well, and with that, I'll thank our panelists for joining us and discussing in the town hall today. And thank you all for joining us. And I think another space to watch will probably be the Petrie-Flom Bill of Health blog. So keep an eye on that and look there for other events to come up soon. Thanks, everyone.